I'm going to go ahead and spare the bubbly introduction to this case because abortion is not a subject that anyone really likes to discuss, but it is one of our 15 cases, is Roe v. Wade, a 1973 case which extended the right to privacy to cover the woman's right to have an abortion. Now, we realize that students have very strong opinions on this issue because not only is this an issue of federalism, the rights of the states, if that were the case, we could have a reasonable discussion about this. But what Roe v. Wade does is it takes two deeply held beliefs of the American people. When we think about the right to privacy that we see not explicitly stated in the Constitution, but throughout the Bill of Rights and the 14th Amendment, we see that Americans generally believe that there's a right to privacy. When it comes down to it, just ask somebody for the code to their phone or something like that. That's private. When you get pulled over and a police officer wants to search your car, that's private. Where's your warrant, officer? So when we think about that, that is a deeply held belief in freedom and the principle of privacy. And then at the same time, on the other side, we have the right to life, which is, of course, in one of our founding documents, the Declaration of Independence, the right to life, liberty, and the pursuit of happiness. But specifically here, that many Americans have a deeply held attachment to the right to life. So with that, we see why this is so controversial, because it pits these two fundamental American values against each other. And the essential question here is, does the Constitution recognize a woman's right to have an abortion as part of a personal right to privacy? Let's take a look at the facts of the case. In 1970, Jane Roe, which this is a pseudonym to protect the identity of the woman who was filing suit. It's kind of like Jane Doe. This is one of those names that, is given out. It's not the woman's real name. So Jane Roe filed suit against Henry Wade, who was the district attorney of Dallas County, Texas. Now, at this time, Texas was one of many states that had an outright ban on abortion, except in a case where a doctor prescribed the abortion in order to save the life of the mother. Roe said that this was a violation of her constitutional right to privacy. So there you have it, that she's saying, I am guaranteed this right to privacy that pretty much clearly exists to most people in some degree or another when you tie together the First Amendment, the Fourth Amendment, the Ninth Amendment, the 14th Amendment, that this right to privacy to most Americans is understood to some degree or another. As far as an important precedent, we want to note Griswold versus Connecticut, which was a 1965 decision in which the Supreme Court placed birth control under the right to reproductive privacy. So Griswold versus Connecticut was a very important landmark case that established the right to privacy, and especially when it comes to reproduction. In this case, it struck down a Connecticut law that banned birth control. In a 7-2 decision, the Supreme Court ruled that abortion is covered in a woman's right to privacy, and the Texas law that banned abortion outright was struck down as unconstitutional. So Roe v. Wade is a landmark case guaranteeing a woman's right to have an abortion as part of her right to reproductive privacy. Now, there is a bit of fine print because it does not say that the states can't regulate abortion. And in this sense, we can compare this to McDonald versus Chicago, that the states cannot pass laws that stop a citizen from being able to keep and bear arms, but the states are able to regulate firearms. In the same way, abortion is treated like this in Roe v. Wade. There is special attention given to the state's interest in preserving the potentiality of human life, and also concern about the age of viability. So, for example, the state's right to limit abortion in the third trimester, okay, that is without question. States can ban abortions in the third trimester to preserve the potentiality of human life and to protect the right of a viable potential life. But at the same time, states are barred from banning abortions in the first trimester. Now, it's the second trimester that gets a bit tricky, and of course, that's where we see the viability viability test. It's important to note that the majority's decision was based on the Due Process Clause of the 14th Amendment. The Due Process Clause of the 14th Amendment reads, "Nor shall any state deprive any person of life, liberty, or property without due process of law." So the majority was deciding that the Texas law, in depriving a woman of her right to privacy, to have an abortion, and having a blanket prohibition, was a violation of Jane Roe's due process rights under the 14th Amendment. And remember, due process is also mentioned in the 5th Amendment. Almost 50 years after the Roe v. Wade decision, Americans remain very divided about the abortion issue, and it continues to be a deeply held passion on both sides. And it was no different with the opinion of the court. Although we have a 7-2 decision, the court produced two powerful dissenting opinions, one of them by Justice White, which read, "I find nothing in the language or history of the Constitution to support the court's judgment. The court simply fashions and announces a new constitutional right for pregnant women, and with scarcely any reason or authority for its action, invests that right with sufficient substance to override most existing state abortion statutes. As an exercise of raw judicial power, the court perhaps has the authority to do what it does today, but in my view, its judgment is an improvident and extravagant exercise of the power of judicial review that the Constitution extends to this court." So Justice White is saying here that he doesn't disagree that the court has the power to do what they're doing, but he believes that this is the wrong decision. Justice William Rehnquist, who would later become Chief Justice of the Supreme Court, and we'll see him in cases like Lopez versus the United States, Justice Rehnquist is using the philosophy of originalism or original intent, looking back to the time when the 14th Amendment was ratified by the states, and what did the country look like at that time? What did the laws look like at that time? Justice Rehnquist writes, "To reach its result, the court necessarily has had to find within the scope of the 14th Amendment a right that was apparently completely unknown to the drafters of the amendment. As early as 1821, the first state law dealing directly with abortion was enacted by the Connecticut legislature. By the time of the adoption of the 14th Amendment in 1868, there were at least 36 laws enacted by state or territorial legislatures limiting abortion. While many states have amended or updated their laws, 21 of the laws on the books in 1868 remain in effect today." So it's important to note here that when we see analysis like this, we are seeing that a judge is using the doctrine of original intent, or otherwise known as originalism. As far as the legacy of Roe v. Wade, I've already mentioned that this has created quite a divide in American politics, a divide that has actually gone on to become paramount in judicial proceedings. There is not a single person that is nominated for the Supreme Court that does not get questioned about their views on abortion in their Senate confirmation hearings. Now, we see that most of these nominees kind of skirt around these questions, but the point being that abortion has become a very contentious political issue and also a partisan issue, as we can see that today's Republican Party is strongly pro-life, today's Democratic Party is strongly pro-choice. Another case that we want to look at is Planned Parenthood versus Casey, a 1992 Supreme Court case where it was hoped by conservatives that the more conservative court would strike down Roe v. Wade. Now, that did not happen. What we want to remember about Planned Parenthood versus Casey is it did not strike down Roe v. Wade, but it did uphold further state restrictions than existed at the time of Roe. So it did not overturn Roe, but it did allow the states to restrict abortion even further. Now, what we've seen lately with the development of new medical technologies, we see the age of viability going down. Of course, we also see movements in several states to restrict abortion even in the first trimester. It is quite likely that this issue is going to go in front of the Supreme Court again, as we've seen that many states have been passing laws that are restricting abortion as early as 20 weeks into a pregnancy, some even sooner than that. So it's entirely possible that we will see this issue come before the court again. Now, given that it was not overturned by Planned Parenthood versus Casey, I think it's very unlikely that we will see Roe overturned and abortion going back to the states entirely, but it is very possible, given the current composition of the court, that the court will weaken Roe without overturning it. So while this issue is far from settled politically, in a judicial sense, Roe v. Wade has become cemented to a point where it's probably not going to be overturned, but we are going to see challenges to Roe v. Wade and possibly some further limitations. So it's something that you want to continue to observe as an American citizen. And with that, I thank you for watching as we've discussed a fairly controversial issue. And even with that, it's always a pleasure.